that he would probably at least need to be able to testify, hey, I did this particular test with these in this particular manner, and I followed these particular, these methods. Consistent like your other cell phone expert did. When's he going to finish his report?
Should be fairly soon, Your Honor.
And it's got to be provided to the defense?
It will be.
So I think it's probably a little much. Yeah, it's probably a little bit probably not ripe quite yet. Yeah.
Premature?
Yeah, ripe. What I was looking for.
What else were you looking for?
Yeah. So let's just you can explain to him that that it would make better sense if we did that. And maybe you can ask him when his report's going to be due, because we can, if worse comes to worse, I can always take it before he testifies. I can qualify him. It took Mr. Worrell probably about maybe 40 minutes or something like that, 30, 40 minutes. So, there's no reason we couldn't do it prior to trial, or prior to his testimony being offered.
Okay. I can go check with him and see if the report might be done and report back before we move.
Okay.
Judge, when you get a second, and when Ms. Rosenwasser comes back, may we approach?
Yeah.
Or Mrs. Smith? We should step up, Rico.
Yeah, sure.
just didn't want to be lost in the shuffle, and I still have an outstanding one, so I just wanted to speak up as opposed to.
Your Honor, he filed that motion only a couple of days ago. As the court knows, I've been here, so I haven't had a chance to respond to it yet. I'm not sure what the
motion is it?
We're still actually, and I'm not blaming anyone here, let me just say that, but we're missing some photo lineups, and I was trying to hold off on filing it, but
That's a continuing discovery issue, so.
Well,
if you don't get it prior to the trial,
well,
or supplementing discovery.
I filed a motion to suppress the identification based on what the transcript indicates happened, but I don't have the actual photo lineup yet in discovery.
Well, of course, until they're admitted, he could have that typical motion. I'm running out of time, so I have to kind of.
I understand. That's fine.
Yeah, before that's admitted, you can sort of take it up.
Thank you.
Your Honor, we confirm Deputy Hall he's on his way. He'll be here. We should be able to take him after Henniger if he's on his way. If he's not here, I can be ready to argue.
All right, we said as far as our issue of the leak for Hall and 8-1?
Yes, sir. Yes, sir, we did. Yes, we
Okay,
did.
all right. Okay, can we call Dr. Henninger?
Absolutely, Your Honor.
Dr. Henninger?
All right, please come to Dr. Henninger. Hey, folks, you guys we're talking. Look, if you all could kind of keep this down a little bit because small pockets of conversation that's where we are, so, or us to be able to hear and go over it. So, to the extent that you need to have a conversation, keep it in low tones or just wait until we have a break, okay? All right, Dr. Henninger, good afternoon, sir. You approach the witness stand. Once you get there, if you would be so kind, you turn face to Ken Gibson and sworn as witness, sir.
Please sit. Remain standing, sir. Raise your right hand. Do you swear or affirm that the testimony you give in this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may lower your hand. You may be seated. For the record, please state your name, spell your first and last word, and state your occupation.
Okay, my name's Dr. Michael Henniger.
Make sure you speak.
Can you hear me okay? Okay, my name's spelled Michael, and then Heninger. And I am a forensic pathologist at the Fulton County Medical Examiner's Office.
Good afternoon, Dr. Henninger. How are you?
Excellent.
Good, good. How long have you been a forensic pathologist?
I started working at Fulton County as a forensic pathologist. It's my first my job, basically, in 1995 in July.
Okay.
So since then.
Okay. And can you tell the court a little bit about your education?
Yes. I started out at Utah State University. I received a Bachelor of Science degree in biology. And then I went to medical school at the University of Utah, and I received an MD degree. I went into the military and did an internship in internal medicine at Keesler Air Force Base in Biloxi, Mississippi. I practiced primary care medicine for a few years. After I finished my commitment to the military, I went back to Utah. I did a 4-year residency in anatomic and clinical pathology, and then I did a 1-year fellowship up in Minneapolis at the Hennepin County Medical Examiner's Office in forensic pathology. And when I finished that training, I came to Atlanta.
Great.
Began to work for Fulton County.
When did you, when did you start studying medicine?
I went to medical school I started medical school in 1982. I did pre-med undergraduate, so basically when I graduated from high school, I started doing pre-med classes. Okay. And even some of the high school classes were, like they teach physiology and biology in high school. So, I mean, I'd have to go back to the 9th grade to really say that's when I started studying things that were academically going to lead to medicine.
Thank you, sir. Are you involved in any professional organizations?
Yes, I am.
And what are those?
Okay, there's 2 of them that are that people in our field belong to. There's one called the American Academy of Forensic Sciences. It's a big, huge group of people that from all different disciplines, not just in medicine. There can be anthropologists and dentists and different areas of expertise. The one that's particularly focused on forensic pathology is called the National Association of Medical Examiners. It's a smaller group, but they're all forensic pathologists, most of them anyway. And they I also belong to the American Medical Association.
Your Honor, at this time, I'd like to move into State's proposal exhibit 16, I believe it is. Permission to approach the witness?
Anybody not seen State 16, Dr. Hannon, you see who? All right, you may approach.
Thank you. Dr. Henninger, what is that, doctor? Do you recognize that, doctor?
This is the version of my CV that I have on my desktop. That's kind of a basic summary of simple basic summary of my CV.
Has there been any alterations to that document?
No, there's, trying to see if it's, I think I had one more article that's on this, but that's just probably since I gave that to whoever did. But anyway.
Any objection to State 16? All right, State 16 is admitted.
Dr. Henninger, am I pronouncing that right?
Yeah.
Okay. Do you have any certifications?
Yes, I'm board certified in anatomic and clinical pathology. I'm also board certified in forensic pathology.
And with those certifications, are there any kind of continuing education courses?
Yes, there are.
Okay. Can you tell the court a little bit about those?
Okay, continuing education, basically, on average, once a year, we have a national meeting that we can go to, and they usually last approximately a week, and their lectures and papers are presented, and there are discussions about various fields. I generally have gone to those. I've gone to more than required some years, and occasionally I do present things. I'm not an academic forensic pathologist. I'm not one of the people that are in the middle of doing that and doing the major lectures, but we attend those, and that's a requirement to maintain a license to practice medicine.
Okay. Are there any tests you regularly have to take?
Okay, they have instituted that, but when I got board certified, they hadn't, and I haven't had to take the tests. So there aren't any of that. I mean, I'd help write the test questions when they request that. I'm kind of, my level of experience, I'm more on that side of it. But
Sure. So I want to kind of transition. How were you trained in performing autopsies?
okay, that's a very good question. We start out, basically when I was an undergraduate in college, my last year, we had an anatomy class at the college, and we had a cadaver that we looked at. So we started learning anatomy at that point. In medical school, we had a year-long course in anatomy, and we did basically one autopsy all year long. So we went through every single thing they could think of. And then when I was a fourth-year resident, I did a rotation in pathology, and they let me kind of do an autopsy and under close supervision. So those are a few, and that's more than is typical for students today, but probably pretty typical for that time. But the real training begins in your pathology residency, where you're required to do a certain number of autopsies. So that's when I started doing autopsies, more than one, and focusing on learning how to do them. And those were hospital autopsies that are basically looking at people's natural diseases, so it's more closely related to medicine, and the forensic aspects aren't really in that. And then when I did my fellowship in Minnesota, the first day I was there, I did a forensic autopsy under supervision. The second day I had a homicide that ended up going to court, and I was under supervision doing that with really close supervision. So that's how you learn, and I did about close to 200 of those that year. And then when you're in practice, you're constantly learning from your cases. You don't just walk into this knowing everything. And then there's the process where we had a fellowship and I've helped train other physicians. So that's kind of how I've learned how to do autopsies. It's a work in progress that keeps going on for your whole career.
And do you typically stay up to date with like developments in that field?
Yes.
Have you ever taught any classes?
Yes, I don't have that in my resume, and they're not that well documented, but I have taught over at Emory. They had several lectures that they have in all different kinds of areas of pathology, and I've done several lectures on forensic pathology at Emory, and they're geared towards pathology residents, not necessarily forensic pathology residents. Most of the teaching that goes on in our office, we do have little kind of one-on-one training sessions with the fellow, but a lot of it's at the what we call the bench or at the autopsy table, where you see something interesting and you show it to the resident, or you're watching what they do and pointing out things they need to do. That's kind of guiding them through this process. So,
how often do you teach over at those classes over at Emory?
Right now, they were canceled during COVID, and then they haven't really started back up. Or if they have, they're having other people do them I don't know about.
Have you ever received any awards for your work?
I don't know, paycheck. I don't, I mean, not really. It's not, I'm not like, the people who get the awards are people who are usually in administrative stage. There's, I don't know, not really, I guess no is the answer.
Has your work ever been published?
I have been involved in writing articles. The person I worked for 20 years was one of the academic forensic pathologists. He was the head of NAME at one point, and he wrote like hundreds of articles, and he encouraged me, and I did do a few. They weren't really required, so I just kind of plugged away at it. So I have on that resume, I've got a list of articles that I've either written or helped write.
Approximately how many autopsies have you done or assisted with over the years?
Well, assisted with really interesting, but just done. I've done at least 250 for 27 years, 250 each year. So that's up over 7,000 autopsies. As far as assisted, depends on what degree, because we have meetings and we talk about the cases, and the more complicated cases we talk about more. And that would be the total caseload of our office, which is over 1,000 a year of just autopsies and at least 2,000 cases. So those numbers get really high, but they're not. I think it would be deceitful for me to say, some big, huge tens of thousands of those.
Sure.
I mean, I was involved in the more interesting ones. Most of them are just,
Have you ever been qualified as an expert before?
Yes.
In which states?
Minnesota and Georgia.
Which courts?
Mostly Fulton County. The first couple years I was here, we worked at the GBI, and I testified. It was kind of Fulton County and GBI, we covered both areas. And I did get to testify in several murder trials in various places around Georgia, not in Metro Atlanta.
And about how many, let me strike that. Have you been qualified as an expert in civil cases as well?
A few.
About how many times?
I haven't kept track, but it's not a lot.
If you can recall, what was the nature of that testimony in those civil cases?
The civil cases I've been involved were usually depositions, and they're usually related to injuries and either traffic accidents or on the job injuries, things like that. That basically they wanted to know the injuries and the cause of death. But I mean, certainly wasn't testifying about all the other things that go into that.
Dr. Henninger, what techniques do you use to conduct autopsies and determine cause of death?
Okay, so there's the autopsy itself, which is like a medical procedure where we examine the body in a systematic way. We have investigators that are similar. Some of them have been police detectives, or they're similar to them, but they collect information, and we evaluate that information. And then we have tests that we do, lab tests. Basically, there's toxicology. There can be other lab tests. We have an X-rays that we look at and take. So those are some of the things that we do. And then I guess the other half of that is documentation, and we take pictures and we create a report.
How did you learn these techniques?
By doing them, basically, yeah, the autopsy itself, when we started way back, the beginning, and then the majority of that is exactly how to do them efficiently, how to do them with chain of custody issues in mind, forensic issues in mind. That happens in my fellowship. And so basically I'm doing a case, but a person that's experienced is standing right there, and they let you go as far as you can. And part of being on the other end of that is, is knowing how to step back and look at a fellow who's training, and let them go just far enough that if they make little mistakes, they're not serious, and kind of stop them before they cause problems, but not let them get, into where they do really major mistakes.
Do others use those same techniques?
Well, yes. I mean, I'm not, my experience isn't great, but from what I can tell from the meetings and from, different talking to people, it's fairly homogeneous across the different offices. There are probably minor details that are different in different places that I'm not very familiar with, but I think that's pretty much the standard way.
Okay. And how would you go about determining the cause of death?
Well, the same thing. I want to look at the information, the circumstances. I want to look at the autopsy, if I did it, or else read the report and look at the pictures if I didn't. I want to see all the ancillary information, and then, think about it. I may even look stuff up. I have textbooks, or else, get online and find reliable sources for answering questions I may not have on the top of my head or whatever, and then make a determination of cause and manner of death.
Do other medical examiners use those same techniques?
As far as I know, all the ones that I'm acquainted with use something very similar to that.
Okay. And do you know, are these procedures published in a textbook?
There's several textbooks that have different aspects of it. I don't know that we have one comprehensive textbook that tells everything you need to know for everything. There's books, a lot of textbooks are just information, like common, like say you might have a chapter on gunshot wounds, it'll tell you about gunshot wounds. And then there are books on procedures, on, how to do basic procedures. And then there are also like uncommon procedure, unusual procedures. And then when you've done it a lot, you can often kind of see where the boundaries are, and you can create like other approaches that are within, the realm that can answer questions.
Sure. What about professional publications? Have those procedures been published in professional publications? Some of them are published. There's books that have been published systematically by people who are familiar with a lot of different procedures, and then a lot of the articles are like, kind of interesting, unusual situation where they had to do something different than usual. So there are books that do that. And typically, how would you stay up to date with the procedures?
Basically, I go to the meetings and talk to people. Until COVID hit pretty hard, I rode the train to work every day. I had 2 hours to read. I just mostly read forensic pathology or general pathology textbooks because, that seemed like it's part of my job. I'm sitting there going to work, it's hard. I might as well read that instead of something else,
Dr. Henninger, is your work ever checked by your colleagues?
Yes.
Okay. Do you check others' work?
Yes.
How often?
All the homicides are reviewed, and then the other reports are, we have a morning meeting where we present the cases and decide what we're going to do. And then at the end of that, we go over the cases from the previous day and to kind of see, basically it's teaching for the fellows and the residents that are there. But it can also, it functions as people can see what everybody else is doing. You can kind of learn. Often people will raise questions, they'll find something, they'll say, well, I wonder what this means or what is this? So that.
Are there standards that basically control your assessments and your work?
Yes.
Are there best practices?
There are best practices is fairly nebulous because if you're really good, you may do better than someone else. But there are definitely standards, and the standards try to describe what is good practice, for sure.
And do you follow those best practices?
Yes.
Who else would you say use the same procedures as you?
Who else uses the same?
Who else would you say use the same procedures as you?
All the people on these reports were using them, and let's see, 2 of them have moved to other offices. As far as I know, they're still doing things similarly.
Do all federal, state, and governmental agencies performing autopsies use those same procedures?
I don't know about the federal government. I think they do. They're mostly military people. They may have their own things, but the states, all the states, their state medical examiner systems, their counties, and I think all those offices are following very similar to our procedures, or at least attempting to.
And did you perform, in this case, an autopsy of a Donovan Thomas Jr.?
Yes.
And did you follow all the standard and procedures that you discussed above?
Yes.
Your Honor, at this time, we would ask the court to qualify Dr. Henninger as an expert in forensic pathology based on his number of years of experience, his background, his training, and the fact that this is well established, accepted field in forensic science.
All right. Okay, then the court will designate Dr. Henninger as an expert in forensic pathology. May Dr. Henninger be currently temporarily excused for purpose of the motion? Yes, sir. All right. Dr. Henninger, appreciate you coming to visit us.
Thank you.
Good to see you. Just don't discuss the testimony anybody except the attorneys in this case. We'll call you when we need you. Okay?
Okay.
Thank you, sir.
Thank you.
Okay, so Mr. Watson, did you talk with Mr. Bernini?
He is. We sent him back on his way. He said he's going to try to have a draft report basically as soon as he can, hopefully before the end of the year, and he'll definitely have a final report before trial. We'll turn it over as soon as we have it.
Okay, all right. And we'll hold off on him for the time being. He's issuing his complete report before he testifies, or you decide to present as a witness in this case. We'll go through a job analysis of the threshold requirements. All right. Okay, so the only person you have this afternoon is
Deputy Hall, Investigator Hall. He is. He said he should be here momentarily. I can give him a call and get you back ETA. Oh, or we can go ahead. I'm ready to do Farley's motions as well. I'm sorry.
let's go ahead. Your colleague and Ms. Smith can go ahead and check on him. And we'll go ahead and let you continue Farley's motion. Part about I think you're going to talk about the duplicative accounts and
The gang constitution.
the duplicative accounts and the gang statute. And have you put Mr. Carlson on the rate to talk before
right. Good afternoon, Your Honor. I mainly rely on Meeks v. State, which is 309 Georgia App 855. That held that a one count of theft by taking was subject to a special demurrer because it was entirely duplicative of another charge that was charged in the same offense. And here, Your Honor, I'm basically asking the court to apply Meeks to this indictment the way it's specifically written. In Meeks, the Georgia Court of Appeals held that the accounts were duplicative because they provided no additional facts by which it can be distinguished from the other count, and it alleges neither a different set of facts nor a different date. And so, Your Honor, that's what I allege, that counts 50 and 51 are duplicative of count 49. Count 49 is where Mr. Farley is alleged, along with Mr. Stillwell, Nichols, and Garlington, to have murdered Mr. Drinks. And in that count, they say, the reason why, Your Honor, this is especially duplicative is it says that Mr. Drinks was an associate of a rival gang. So essentially what I'm asking the court here is to find it duplicative, because I know the state's going to say that a gang activity charge and a murder charge are not duplicative, even if it's that murder that is the basis of the gang charge. But, Your Honor, I think that this can't survive a demurrer under Meeks because they write up count 49 as a gang charge. They just don't write the caption. And, Your Honor, the caption is not what holds, it's the substance. And so here in count 49, the substance is the same as counts 50 and 51. Had they not put in that part where it says an associate of a rival gang, then I get it. There's an extra set of facts that, oh, we're saying you killed this guy, and then in this other count, we're saying you killed him as part of gang activity. But 49 says an associate of a rival gang. So because they wrote that in there, and they didn't have to, that's not part of the malice murder statute by any means, but they chose to allege it that way. And so within the four corners of this indictment, of which Mr. Farley is entitled to an indictment perfect in substance and form, here it's duplicative. Had they not put that, it wouldn't be duplicative. But what I submit to the state, what different fact is alleged in counts 50 and 51 that's not alleged in count 49? Because in count 49, they say it's an associate of a rival gang. So if you say someone has an associate in a rival gang, by inference, you're saying that that person is in a gang. Essentially, count 49 alleges Mr. Farley to be in a gang, and it alleges that the person killed was a rival of the gang that Mr. Farley is supposedly in. So count 50 and count 51 that allege the criminal street gang activity with the murder of Mr. Drinks as the subject matter, Your Honor, those are both duplicative of count 49 because they included count 49 as gang activity. So looking within the four corners of the substance of these three counts, there's nothing different in count 51 or 50 that we don't already have in count 49. For that motion, yes, Judge.
Okay, talk to me about the unconstitutionality of the gang thing.
Sure, Judge. So,
And you understand the Supreme Court consideration, right?
I understand, Your Honor. I don't think the Supreme Court's going to consider anything with regards to Mr. Farley because there won't be a conviction, but just out of caution, I do think maybe the United States Supreme Court or possibly some other court might review this, Judge. So I do... Right.
What's your good faith basis to challenge?
Yeah, I can explain that, Judge. The good faith basis is that Rule 418 in combination with the Georgia gang statute just completely flies in the face of the most fundamental aspect of our government, which is checks and balances between the three branches. You know, we have Your Honor representing the judicial branch, we have the state representing the executive branch, and we have myself and the other attorneys representing individuals and people in the state of Georgia. And so how it's supposed to work is that we're supposed to be checking each other, we're supposed to be balancing each other. But what we have here is, Your Honor, Rule 418 just completely circumventing Rule 404B and rendering 404B meaningless and robbing both the people of the state of Georgia and the judicial branches of the state of Georgia of any sort of check on the authority of the state to circumvent the legislature, who's elected by the people of Georgia to write the statutes, who wrote 404B. And Your Honor, under 404B, as the court knows, other acts are not allowed in for propensity. They're only allowed in for limited purposes like intent, motive, absence of mistake.
Wouldn't you agree that it's a different statute promulgated for different reasons?
Exactly, Judge. And what's the huge problem here is that our grand jury proceedings are entirely secret. They're not transcribed, and there is no mechanism for either the people of Georgia or the jurists of Georgia to check the state to stop them from doing what this leaves open to be done. So, for example, which is, Your Honor, they might in bad faith, let's say we have a murder case, and that person accused of murder has an aggravated assault, but there is no other way to introduce that except for propensity. So the judge would say, as the state would know, that, you know, I'm denying your 404B, this is propensity, that's not allowed. Our legislature does not allow propensity. However, 418 does allow propensity, and that's what makes the gang statute and rule in combination with Rule 418 so unconstitutional under the United States Constitution. Because what's to stop the state in a secret, untranscribed grand jury proceeding in bad faith just throw on a gang charge onto the murder charge, then... Right, Your Honor, but there's no one to check them. They're doing it in secret, and it's untranscribed, so there's no one to hold them accountable. We have rules, but without enforcement and accountability, the rule is meaningless. And so 418, in combination with the Georgia gang statute, has made 404B meaningless, because all they have to do is throw a gang charge on there in violation of the rules of ethics, which happens from time to time, and they can choose to violate that behind closed doors, untranscribed, and then they can throw up their hands at the end of the trial and say, oh, the directed verdict got granted. We didn't know that was going to happen, wink, wink, but they did know. And the reason they did it and put it on there, even though they knew it would be dismissed by directed verdict, is that so then they can use 418 instead of 404B, and then bring in, for example, a past aggravated assault for propensity, which is exactly what the legislature didn't want the state to ever be allowed to do. And so there is no... Right, Your Honor, but if we didn't have the gang statute, then we couldn't accuse someone of gang activity, and then we couldn't apply 418. We would have to apply 404B, and we wouldn't be talking about propensity. But
Evidence of court, as you know, under law.
Judge, I can't hear you in the back.
So you understand that evidence under our evidence code, Title 24, may be used sometimes for differing purposes, right? So, right?
yes, Judge.
So under the gang statute in 418, it's a little different than 404B and the other purposes for which evidence is admitted, right?
Yes.
Okay, all right.
And that's just exactly, it is the existence of that, Your Honor, that I find to be just totally unconstitutional, because now there is no way to do checks and balances. It's just whatever the state wants.
The legislature wrote the gang, or enacted the gang statute, and they enacted 418, right?
Yes.
So they obviously had knowledge of 404B, correct?
Yes.
All right. So, I mean, I understand your argument. Is there anything else you wanna put forth?
No, Judge. Just,
Okay.
I just ask you to grant that, and then the state can appeal something for once instead of us, appealing everything.
Okay. All right. Ms. Rosenwasser? Any other motions? I think I've dealt with the other. Only one is the 418, and I'm waiting on Mr. Carlson.
Yes, sir. The only other thing I have that I failed to mention is I did have an amended discovery motion that the state's mostly accommodated, but there's one aspect they're not accommodating that I'd like the court to
What is that?
compel them. They relatively recently, sent out these gang profiles on each of the defendants, and then nowhere in the discovery does it say who wrote those profiles and when they were written. And their written response to my motion says, well, you can just call the law enforcement witnesses. But that's exactly why I need Your Honor to compel them to tell me which law enforcement witness produced which gang profiles and when, because even though the state might try to say that's not exculpatory, the discovery statute says it's not only exculpatory things that they have to give us, but anything that might lead to something exculpatory. So the way they've described this gang profile of Mr. Farley, I think they wrote that up after this case already started, and if that's the case, that definitely impacts, my absolute theory of innocence.
Have you had any conversations with Ms. Rosenwasser or Mr. Smith or anybody else in regards to this issue?
No, Judge, only just through our written responses to the
And
motion.
why don't you have a conversation with her about that? Madam, or is it that are you all willing to, or can you give him that particular information?
Your Honor, I don't want to speak out of turn. I would just request Mr. Farley contact the trial team. I would request Mr. Farley contact the trial team leader to get an answer on that. I do not want to speak out of turn, at least without confirming with them. If he'd come up to me about this earlier, I could have relayed that message in a few minutes.
Okay. So why don't you have a conversation with Ms. Love or Ms. Hilton, and then if it continues to be an issue, I'll certainly deal with that. Okay?
Yes, Judge.
Hold on. We got Mr. Carlson here who can talk about 418. Do you want to go ahead and finish your 418 argument, sir, and then I can let Mr. Carlson respond to that?
No, Your Honor. Just to perfect the record, I also challenged the gang statute for violating freedom of speech and freedom of association, but I don't have further argument about that. I just have it in my motion. Everything I object to about 418, I've already said to the court.
All right, Mr. Johnson?
Yes, Your Honor. On behalf of Mr. Eppinger, I wanted to join in Mr. Menendez's motion.
Did any of you ever listen to Mr. Harvey? I hate to cite to him all the time. I hate to cite to him all the time. But he did you all such a solid. He said, look, unless you opt out, everybody else gets to opt in, right?
Well, yes, Your Honor.
Okay, so add to it.
I'm going to add it specifically as it relates to Mr. Eppinger.
Okay, so let's take care of that.
Yes, Your Honor.
But if you start replicating, I'm going to cut you off, all right?
Your Honor, the court is aware of Mr. Menendez's arguments.
Just heard it.
Just like to
And
say,
read the motion.
Yes, Your Honor. As it
Okay.
relates to my client, Mr. Eppinger, we would contend that I believe it's counts. Let me find the exact one, Your Honor. I believe it's counts 38 and 39 of, no, I'm sorry, 28 and 29 of this matter, which charged my client with possession of a firearm by a first offender. The two counts are exactly written the exact same. They do not allege any different information whatsoever. And this counts 34 and 35, Your Honor. They allege that my client was in possession of a firearm on a particular date after having been convicted, placed on first offender for a particular crime. It is the same crime, the same date as listed in counts 34 and 35. There is no additional information required or added in this that would differentiate these two counts, Your Honor. So based on the similar arguments made before, we do believe that these counts are duplicative and should not be included in the indictment, Your Honor. Well, at least one of them should not. Thank you.
That it?
Yes, that's it, Your Honor.
Okay, all right. All right, Mr. Carlson. Can you speak to Mr. Menendez and by implication the rest of the defendants who have specifically decided to opt out are seeking to have this court declare Georgia Rule of Evidence 418 unconstitutional. So if you would speak to that, I would appreciate it.
May it please the court, Your Honor?
Go ahead.
And if I may, Judge, approach the court reporter with my car.
You may.
Thank you. Your Honor, again, Mike Carlson, Executive District Attorney on behalf of the state, responding to the constitutional challenge. I believe it's actually to 1615-4, the charging provision of Georgia's Street Gang Terrorism and Prevention Act, as well as Official Code of Georgia 24-4-418, which is an evidence code provision that exclusively applies to cases charged under OCGA 1615-4, and that is by language of the statute. So, Your Honor, let's take a look first what we have here. These are essentially facial challenges to both of these statutes before the court. There's no acknowledgement in the briefing that at least has been reviewed by this Assistant District Attorney of the controlling or persuasive authority involved. And that begins with the fact of a presumption that a Georgia statute is constitutional, presumption that the challengers, the court knows, must rebut in cases like State versus Brannan, B-R-A-N-N-A-N, 267 Georgia 315, 267 Georgia 315, that's a 1996 case, sets forth. Also, in a facial challenge such as this, the opponents have to demonstrate that there is no set of facts under which the Gang Act or 1615-4 would be valid. A case for that out of the 11th Circuit is Benning versus Georgia, 391 Fed 3rd, 1299. 391 Fed 3rd, 1299, that's an 11th Circuit case from 2004. So accordingly, these challenges should be denied and the motion should be denied. Now let's take a look first at the challenge, which, and again, my apologies for not being here for all of the argument, but based on what I did here and based on the briefing, is a First Amendment challenge. Well, that was dispensed with, Your Honor, by our Supreme Court in a 2009 decision, Rodriguez versus State. 284 Georgia 803, 284 Georgia 803. Now, Rodriguez was strictly a case under OCGA 1615-4A, that's Alpha Judge, the primary charging provision of the Street Gang Act. But notably in Rodriguez, the court explained, and the late Justice's opinion affirming Judge Hancock of DeKalb County's decision, pointed out that the gang statute prosecutes conduct, not association and not expression. And I'll read a quote from the case. Criminal gang activity, quote, is not protected activity even when committed by a group exercising their constitutional right of free association, because, of course, there is no constitutional right to commit criminal gang activity. And when that criminal gang activity is committed by an individual who is a member or an associate of a criminal street gang and participates in the gang through the commission of that criminal gang activity, then the additional offense of a violation of 1615-4A can be brought. Now, there is a complaint here about 1615-4B. That is the commission of those offenses in order to increase or maintain status in the gang. Again, that is criminalizing behavior, not expression. So, as to the double jeopardy claim that we saw there, at the outset, let's direct the court and the record and opposing counsel to OCGA 16-15-4M as in Mary. That is a statutory non-merger provision that is housed within the Street Gang Act itself. And our Supreme Court and our Court of Appeals have specifically dealt with the issue of whether or not someone being charged with multiple subsections of the Street Gang Act and being sentenced and convicted, or convicted and sentenced for those subsections as well as the predicate offense, violates the Constitution. No merger, no violation in that case, Judge. And I want to take us first to the Court of Appeals case on that, Judge, which is Nolly versus the state, wherein the specific quote is that in Nolly, let me actually, before I get to the quote, the defendant was charged with more subsections than any of the defendants here were. And that was actually, there was an A, B, D, and E violation in addition to the underlying predicate. And the courts there said in Nolly from the Court of Appeals, and I'll have that citation to you in a second, Your Honor, from my co-counsel, there was no violation of merger or double jeopardy rules. Lupo versus State from the Supreme Court, 300 Georgia 233. That's a 2016 case. The gang activity counts did not merge, as that crime and malice murder each require a proof element that the other does not. And of course, that's consistent with federal and other state and Georgia Rico authority as well, Your Honor, which I'm happy to provide. Then there was Anthony versus State, again, this is at 303 Georgia 399, We previously had rejected the idea that all gang offenses must be gathered into a single gang activity charge. So the subsections of the Street Gang Terrorism and Prevention Act all have different elements. Those elements are different than the predicate offenses, so they all can be charged, convicted, and sentenced separately. And in fact, there is a statutory non-merger provision within the act itself. So, Your Honor, the constitutional claims fail in terms of 1615-4. So now let's look at a later enacted statute, 24-4-418. Now this is a provision that is unique to Georgia and only applies to cases that are charged under Georgia's Street Gang Terrorism and Prevention Act. And it's patterned after, Judge, the same evidence code provisions that apply in sexual offenses and lawsuits arising from acts of sexual misconduct. Georgia has those at 24-4-413, 14, and 15. They're in the federal rules of evidence under the same numbers, and I believe, Your Honor, they're also in the military rules of evidence under the same numbers. So the question is, does the admission of character evidence somehow in and of itself violate the Constitution? There's been no case law provided to that effect by the opposite side, and while the U.S. Supreme Court, I believe, has yet to definitively answer that question, there is certainly no controlling case law to say that these statutes, which are used and approved around the country, somehow violate the Constitution. So we ask a question, is there a due process problem here? Well, Rule 403 applies, Your Honor, and although it is a presumptive admissibility statute, that does indeed allow other acts that qualify as criminal gang activity to be admitted for any purpose, including criminal propensity. Those parallel the rules that apply in sex offenses, in federal courts and in Georgia courts, and quite frankly in other states, California, for example, Your Honor, there are similar rules that apply in elder abuse cases, special needs abuse cases, domestic violence cases, as well as in non-sexual child abuse cases. Those have been upheld, and you'll see in our brief we've provided you with jurisdiction after jurisdiction after jurisdiction where rules that parallel this one, in fact, have been upheld constitutionally by federal and state courts around the country. An additional case on that, Your Honor, State versus Gee, G-E-E, that is at 388 Wisconsin 2nd, 68. 388 Wisconsin 2nd, 68, a 2019 case, and where they say, they quote, the United States Supreme Court of Dowling versus U.S., 493 U.S. 342, 493 U.S. 342 at 1990, whether the introduction of this kind of evidence is so extremely unfair that its admission violates fundamental concepts of justice. Well, Your Honor, this type of evidence, even without the gang statute involved, even without 418, is generally admissible. The rules of intrinsic evidence are relaxed, generally speaking, when it comes to racketeering cases federally, and of course, in sexual offenses, even without a 413 or a 414, those were more easily admitted under our former evidence code. And just to go to a military case on that, Judge, U.S. versus McDonald, 53 Military Justice 593, 53 Military Justice 593. Again, a direct attack there on 413 and 14 on due process grounds, and just stating that a review of the pertinent appellate decisions indicates the courts have uniformly held that such constitutional concerns are satisfied by the proper application of the Rule 403 balancing test. So is this a statute that allows other acts in presumptively? Yes. Does it allow it in for all relevant purposes? Yes. But that was the design of the statute. In fact, it's right there in the enabling language of the statute in the preamble, quote, to improve the ability to prosecute street gang terrorism and provide for the admissibility of similar transaction evidence in prosecutions for criminal street activity. And that, of course, corresponds directly with the purposes of the Street Gang Act under OCGA 1615-2 to eradicate that kind of crime. And those are the words of our General Assembly as part of and a response to a state of crisis. So the constitutional challenge to 418 fails. 418 applies. There's not a due process consideration here because, again, the statute is tailored to these considerations, and certainly criminal street gang members committing criminal street gang acts are not a protected class that would raise equal protection concerns. So now we go to this last issue of, so the constitutional challenge to 418 fails on its face. So now we get to the issue of whether or not the other acts evidence, the uncharged misconduct to be admitted under Rule 418 requires a prior conviction under 1615-4. That issue was just argued in front of the Georgia Court of Appeals successfully by Assistant District Attorney Rosenwasser in the case of State versus McKinney. I've got the Lexis site for that, 2022 Georgia Appeals Lexis 545, 2022 Appeals Lexis 545, where the Court of Appeals noted that the language of Rule 418 itself does not require a nexus in terms of the other acts evidence to be brought in between the gang, the crime, and the defendant. Only that the prior offense, the other acts, could be subsequent classify under 1615-3. So for any evidence the state is going to proffer under 24-4-418, if that offense qualifies as criminal gang activity under 1615-3, it thus becomes presumptively admissible for all relevant purposes under the plain language of 24-4-418. So, Your Honor, with regard to the facial constitutional challenges, we request that the court deny those respectfully. With of course, to the specific challenges to 1615-4 and 418 constitutionally, we ask that those be denied, and we also ask that that the court deny now and apply prospectively during the trial of this case 418 properly and reject any argument that the other acts have to have constituted a convictable offense for 1615-4. Thank you, Judge.
Okay.
And Your Honor, none of that addressed any of my arguments about unfairness. It just cited to Georgia statutes and then conceded that 418 is unique to Georgia, which is why I'm challenging it so that it can be reviewed by a higher court. Because if you don't challenge anything, Your Honor, in this system of a living constitution, you know, nothing can change. And there have been plenty of times in our history, and even recently with the Dobbs case, that there's just things have changed and courts find something to be unconstitutional. Here,
Well, you've made a constitutional challenge. I mean,
Right,
so,
Your Honor.
So if and when this case is reviewed, our Supreme Court will consider those particular issues.
yes, Judge, and I just real quick to perfect the record want to address a couple of things. He said, the state said I didn't address any actual authority, but I did. In the very first paragraph of the motion, I say that this is a violation of the 5th, 6th, and 14th Amendments of the United States Constitution. It allows propensity, whereas 404B doesn't, without any rational basis. Under the 14th Amendment, for there to be any kind of discrimination, there has to be a rational basis. The basis the state articulated is to eradicate crime. But what is the rational basis that gang activity is more important to eradicate than murder or rape or child molestation? So why should an accused rapist not have propensity in his trial, but an accused rapist where the rape was part of gang activity that the state knew couldn't survive a directed verdict, oh, now we got to eradicate that? That's what's not fair, Your Honor. There's no rational basis here under the 14th Amendment. It's unique to Georgia, and I don't think the state even said this hasn't been challenged. This hasn't been addressed exactly by the United States Supreme Court, and so under all that, Your Honor, I do want to challenge it and get a ruling for this court to preserve that issue for appeal.
All right, Mr. Carlson, you want to address the issue of whether or not this is a rational basis and the correct constitutional standard?
Certainly, Your Honor. This is the parallel provisions federally that apply in sex crime cases have been on the books since, I believe, 1996. There has not been one successful constitutional challenge to any of them cited by the defense. And, of course, the state has provided the court with just to the contrary. In terms of whether or not there's a rational basis here, the legislature in the preamble to the Georgia Street Gang Terrorism and Prevention Act, well, let me change that. In the preliminary language of it in OCGA 1615-4 talks about the state being in a state of crisis due to criminal street gang activity, violence to include murder. So the General Assembly looked at that situation and enacting the gang statute, and of course continued to strengthen those laws in the face of that state of crisis. Again, that's our General Assembly's terms, all the way up into drafting 24-4-418. And I would point out, Your Honor, that this is one of 4 specialty evidence code provisions that particularly applies in Street Gang Act cases. There's 1511-703, 15-11-703, which provides for the admission of juvenile adjudications in cases prosecuted under the Street Gang Act. There is 16-15-3, which is housed within the Street Gang Act, which allows in evidence of the customs and behaviors and symbols of gangs, among other matters. And then there's OCGA 16-15-9, which allows for the admission of other criminal gang activity of the gang. So there is certainly a surrounding statutory body that demonstrates the importance to our General Assembly, which is the fact finder here, that having specialized statute to facilitate the admission of street gang activity, whether by an individual defendant or whether by the gang itself, is clearly something that is necessary for public safety. Just like in the case of the sexual offense provisions or the evidence code provisions that connect with sexual offenses, that those needs to allow in other acts at a different level than would be allowed under 404B would be. So these are legislative determinations. Again, we're not talking about a suspect class here in the constitutional sense under equal protection, and due process is satisfied because Rule 403 applies, and the Court of Appeals was absolutely clear about that in the McKinney decision. So again, we don't have a recognition of Rodriguez in terms of 1615-4 by the defense in this case. We don't have an acknowledgement of any of these cases pertaining to similar statutes from around the country or federally. And again, we have a constitutional statute that was enacted by the General Assembly to deal with the state of crisis of gang activity.
Okay.
Thank you.
Thank you, Mr. Carter.
Very, very briefly, I don't think that argument about...
Don't get back to the podium. Stay right there. Stay right there.
Yes, Your Honor, that argument
All
about
right.
403 just doesn't hold up because of the propensity. For example, 403, we're balancing probative...
But it's a specialized statute that the legislature enacted for purposes of this particular issue. So I've heard your argument. Is there anything else you want to add?
Yes,
I mean,
just to add that under 404B, propensity is not allowed, so propensity is not probative. But under 4A...
but that's the no. It's the test after you look at whether or not 418 still requires 403 to be applied. I mean, so that's your check and balance. And the recent case that Mr. Carlson just cited in State versus Kinney, that was in the Lexus site 22 Lexus 545. That's what our Court of Appeals has determined in that respect.
Well, yes, Judge, but...
So you disagree though?
Yes, we can...
Okay. All right.
That's okay, Your Honor. What I do want to say, though, is that because propensity is allowed under 418, and you only say that as if, they're now giving probative value to propensity and allowing 403 to consider propensity as probative value, which allows it to outweigh prejudice in a way that it shouldn't.
No, it doesn't outweigh prejudice because you still have to balance it under 403.
Yes, Judge.
I mean, look, all good. I mean, the argument in a number of cases is, oh, this is prejudicial. Good evidence certainly is prejudicial under a lot of times, under a lot of circumstances. However, 403 being a balancing test requires the court to not just look the other way, hold its nose, but I still have to make sure that the balancing test under 403 has been met. So there's your safeguard.
Yes, Judge. I just think that the balance turns out differently if we consider propensity, whereas if you don't in certain cases. But I understand that the court might disagree. And just lastly, for the record, I don't think at all that being in a state of crisis is a rational basis to survey due process rights.
Well, here's the thing with as you well learned in law school, right? There's 3 levels of constitutional scrutiny: rational basis, intermediary scrutiny, and strict scrutiny. And that for public safety, the bar's pretty low. I mean, as a general rule, and that the states or governing bodies are free to, you know, that's the one that usually they win on most of the time, is for safety of the public. So if that's what the statute was indicated or was enacted to deal with, and if you look at the preamble when they did it, it does say, you know, we're in a state of crisis in terms of crime and other things, and that was the basis for them to enact the statute. So good luck on that. But okay, but you know, I mean, yeah. Look, I can't, you know, say enough that you're not representing your client, you're representing him well, and you know, you preserved it for appeal, so you've done your job. Okay.
The very last argument I want to preserve for appeal is that the reason I don't find that to be a rational response to crisis is because there's so many other ways that's rational to respond. For example, fixing school system or defects or all these other things that you can actually address the crisis instead of stripping away our due process.
Okay. Well, I'm sure that you'll argue that very well to our Supreme Court. Okay, if and when it's taken up. All right. Anybody else? I saw saw some other people maybe want to get up. Mr. Hoover or anybody else before I rule? Okay, I know all of you adopt Mr. Menezes' motion and his argument. Okay, all right. Ms. Rosenwasser, let me let you finish before I go ahead and rule. I think that you were going to talk with me a little bit about the issue of the duplicative counts as well as the constitutionality of the Georgia gang statute. Is that correct?
Yes.
And I think that will conclude, at least for the time being, Mr. Menezes' motions, until such time as we're able to hear those particular other witnesses, the witnesses that will require, motions that will require witnesses, I should say.
Yes, Your Honor. So first, as to the duplicative counts, if I understood Mr. Farley's written motion correctly, it was a little different than what we heard today, but I'm happy to respond to all of it. So first of all, in his written motion, it seemed as though he was complaining that counts the indictment, later in the indictment, 50 and 51, mirrored some of the acts under count 1. So to respond to that first, Your Honor, first of all, as to count 1 acts 173 and 176, those are acts under the Rico count. They are not separate counts. So what's really going to drive us both through this conversation and through the addressing of what Mr. Farley talked about today, where he alleged that murder and criminal gang activity are duplicative of one another, there's some language that guides us through that. And what I cited to in my brief is the language out of Williams versus State, which is a 2020 Georgia Supreme Court case. It's in my brief, but if the court wants to cite, it's 307 Georgia Supreme Court 778. And in that case, the court said, the United States Supreme Court observed that a draftsman of an indictment may charge crime in a variety of forms and may cast the indictment in several counts, whether the body of facts upon which the indictment is based give rise only to one criminal offense or to more than one. Further, by an indictment of multiple counts, the prosecutor gives the necessary notice and does not do the less so because at the conclusion of the state's case, the defendant may insist that all counts are merely variants of a single offense. Here, the state was properly permitted to charge Farley's act of committing a gang murder, a gang-motivated murder, in numerous ways. The state was permitted to charge Farley with participating in the Rico conspiracy from the YSL criminal street gang, and the state was entitled to allege acts that were in furtherance of that criminal conspiracy, as alleged in count 1. In count 49, 50, and 51, the state was entitled to separately charge Farley for the act of murdering Mr. Drinks and for participation in criminal street gang activity.
Which counts are those again? You said count 1?
My understanding is that Mr. Farley was challenging count 1, acts 173 and 176.
Okay.
And then also counts 49, 50, and 51. 173 and 176, acts, count 1 acts 173 and 176 are Farley and his co-defendants' acts of murdering Mr. Drinks and participating in criminal street gang activity through that murder. and those acts are alleged as acts in furtherance of the YSL Rico conspiracy. And then additionally, Farley is separately charged in counts 49, 50, and 51 with the murder and participation in criminal street gang activity. With the actual, those are the charges. So the charges that he's facing relevant to this count are that Rico charge, the murder charge, and the 2 gang charges. And the gang charges are alleged under separate code sections, separate divisions of the gang statute. So basically, these counts are not all the same, so this court should deny Farley's demur. And when I looked at this, what I believe is that this is a situation that should be analyzed similar to when a defendant complains of a double jeopardy violation. And I believe that this court should adopt that framework to analyze this challenge. The double jeopardy framework is that a single offense may be an offense against 2 statutes, and if each statute requires proof of an additional fact which the other does not, an acquittal or conviction under either statute does not exempt the defendant from prosecution and punishment under the other. So I think to look here whether these counts are duplicative, it is whether it's similar to if we're looking at a double jeopardy or merger analysis. And here, these counts, none of these counts are the same. Count 1, count 49, count 50 or 51. Each of these counts requires the state to prove different elements. Simply because the state added language to certain counts stating that the victim about his gang status or gang affiliation, that does not mean that the counts are duplicative. It simply is different ways of alleging the act of committing a gang-motivated murder. These counts have different charging elements, and what's important is you look at the elements of each count. So Farley is charged in count 1 with Rico. Murder is not an essential, killing someone is not necessary to prove a Rico conspiracy violation. Same thing with participation in criminal street gang activity. Committing murder, killing someone, is not necessary to prove that someone violated the Criminal Street Gang Act. They could also be convicted of that and of murder, but it's not a situation where that's going to be a duplicative count. Those are different acts. And acts is probably the wrong word due to the Rico. Those are different actions taken by the defendant. They're differently charged, and that's completely appropriate pursuant to the Georgia Supreme Court, which quoted the United States Supreme Court. The United States Supreme Court case is United States versus Universal CIT Credit Corp. 344 United States 218, 1952. So here, Your Honor, the counts are not duplicative. They each require different elements. The state must prove different elements to show each conviction. Your Honor, these counts are in no way duplicative. Mr. Farley's demur should be denied.
Okay. Turn to the issue of the constitutionality of the gang statute, Georgia gang statute.
Yes, Your Honor. So turning to that directly, I think it's pretty clear that this has already been challenged by in the Georgia Supreme Court within the last 15 years. That was in Rodriguez versus State. And in that case, the Supreme Court of Georgia unanimously held that the primary charging provision of Georgia's anti-gang laws, OCGA 1615-4, is constitutional. Farley has not shown why this court should not follow the ruling of Rodriguez or even attempted to distinguish Rodriguez. So therefore, Your Honor, we believe that this is, it's already been ruled upon. This is a challenge that has already been made. This statute is constitutional. And Your Honor, going into the challenges to each of these, to the extent that Farley makes a First Amendment challenge, Rodriguez versus State held that criminal gang activity is not protected activity even when committed by a group exercising their constitutional right to free association. So that's already been held. Again, I think Mr. Carlson went into this as well, but to the extent he didn't, or the court has further questions, additionally, Anthony versus State loop specifically, and that's 303 Georgia Supreme Court 399, that's a 2018 case. The Georgia Supreme Court specifically rejected the idea that all gang offenses must be gathered into a single gang activity charge. In Lupo versus State 300 Georgia Supreme Court 233, that's a 2016 case, they found that an individual can be charged with separate violations for each of the gang statutes. So that's not a reason to find it unconstitutional. And generally, Your Honor, it's just been clear that this has already been challenged and been rejected, and Farley has not shown why this court should not follow pre-established case law. And Your Honor, I do want to provide the court additionally with the Nolly site that Mr. Carlson referenced. That's 335, Georgia Court of Appeals 539, 2016, and that actually goes in support of both his case and his argument and my argument.
Okay. Okay. Okay, councilors, appreciate you all giving me some time to collect my thoughts on this particular issues. As it pertains to Farley's motion in regards to amended and special demurrer 7, duplicative counts, this court has considered that Farley is charged in count 1, acts 173 and 176, and counts 49, 50, and 51. And applying, as was mentioned, Williams 307, Georgia 778, these counts are not all the same, where they require different elements of proof, and Farley's motion on that particular issue is denied. As it pertains to the constitutionality of the gang statute, which is 1615-4, this court has considered the council's arguments, in particular Rodriguez versus the state, which is a seminal case dealing with the constitutionality of this particular statute at 284 Georgia 803. The proponent, Mr. Farley, has not shown how Rodriguez is not constitutional. It's not. This particular statute deals with. It doesn't protect activity as authorized by the First Amendment in terms of freedom of association. So it's not a protected activity. So criminality and the prosecution thereof of that is different than the issues under the First Amendment in terms of freedom of association as authorized or guaranteed to us by the First Amendment. So Farley's motion on that issue fails as well. In terms of the motion to declare 24-4-418, admissibility of gang activity. I agree with Mr. Carlson. The facial challenge fails under Brennan 267 Georgia 315, and the First Amendment challenge under Rodriguez fails. Our Georgia Supreme Court is dealt with that issue accordingly in the case just cited. Mr. Farley has also challenged a number of issues involving 16-15-4, which prosecutes conduct, not associations, the court just mentioned earlier. 16-15-4B addresses behavior. 16-15-4M, in terms of the double jeopardy argument, there is no merger. I agree with Mr. Carlson for the and Ms. Rosenwasser for the propositions as stated in Nally versus the state at 335 Georgia Appeals 539, Loophole versus the state 300 Georgia at 233, and Anthony versus the state at 303 Georgia 399. In terms of the constitutional challenge of 418, the issue of uncharged misconduct, there is a built-in mechanism, as I talked with Mr. Farley, counsel, Mr. Menendez, about the issue of it requires the application of the 403 balancing test, and that also is found and is written by our appellate court in State versus McKinney. The Lexus site 202 Lexus 545 has been provided by Ms. Rosenwasser already. So the court is of the opinion and agrees that the issue is not nexus in his classification. So Farley's motion in those regards fails. And in terms of finally his constitutional classification of 418, the preamble, as our legislature has indicated before enacting 418, and that's 24-4-418, is the reason was that our state was in a state of crisis in terms of criminality. So 16-15-4 and 24-4-418. As I mentioned earlier, Mr. Menendez, that we certainly have 3 levels of constitutional review and review to challenge the constitutionality of statutes: highest strict scrutiny, intermediate scrutiny, and then rational basis. And since our legislature has indicated that the purpose of the statute is one of the specialized statutes in terms of public safety, public safety is a relatively low bar for a governing body to meet, and most statutes that are enacted for that particular purpose are found to meet that standard. And for those reasons, the court is going to deny your motion in terms of constitutional classification. So that, I think I've ruled on everything at this point in time. Mr. Carlson and Ms. Rosenwasser, if you would prepare a suitable order as quickly as possible to permit us to go ahead and let us enter that in the record, that would be greatly appreciative. Okay, all right. Mr. Johnson, you stood up for something?
Yes, Your Honor. As you were aware, we had joined in on Mr. Menendez's motion with regards to different counts in the indictment. I did not hear anything from the state as it relates to that. I know that the court just issued a ruling as it relates to the counts that Mr. Menendez brought up, but I did not hear anything as it relates to the matters that I brought.
Which counts are you talking about for your?
435.
You want to address that, Madam or sir?
Your Honor, I can certainly try to address it right now. I haven't done it. This was not written, so I don't have a written response for it. Your Honor, to the extent he's challenged, I think this is Mr. Effinger, is challenging only 34 and 35. Your Honor, if I could just have a few moments to review.
I tell you what, I'm going to reset. Did you file a written motion, sir?
Not on that. I joined in to Mr. Menendez.
Say again?
No, Your Honor. I joined in to Mr. Menendez's motion.
But it's a new count, so I didn't know if he was.
Yeah, it's not the same. It's not the same issue because that count doesn't apply to you. It only applies to him. So you probably need to go ahead and reduce it to writing. But I'll go ahead and let her go ahead and do that. No, I won't take it up now, but because I'd like to go ahead and rule on. There are a lot of things I still have yet to rule on. So the way I can treat it, ma'am, I'll give you about 10 minutes, and then we can go ahead and finish that up, if you don't mind. I need to. All right, we're going to go ahead and do that. Councils, since I can't talk with all of you, can you all send a representative up here to the bench, please? And then the rest of you can pick one or two of you, and then I can go ahead and I'll talk with you.